The episode of PLA with myself, Nick, and Bruno. We've got 3 questions today, and then we'll just do the first one with Nick, second one with Bruno, and then we'll go back to Nick with the third one. The first question, Nick, goes as follows: the tenants that we charged for sewage charges after they moved out due to a mistake by the Brodie corporate is refusing to settle the account. They are still saying that they've concluded their tenancy at the said address and are not liable for the said expenditure, which is the sewage charges. That is their final stance on the matter, and they're requesting to be kindly basically left alone via emails regarding this matter. And then the question is there any legislation that we could quote to assist us in getting these funds from the previous tenant? Nick?
Okay, so let's just deal with the assertion made by the tenant at this point, because what the tenant says is, I'm no longer an occupant in the premises, and therefore no charges can be levied against me. Okay. If you deal with a question like that, the truth is that doesn't have any bearing on the fact whether you're liable for charges or not. Okay. It is entirely possible that once a tenant vacates a premises, there might be a charge which is levied against them. Think about electricity or water, which the municipality does in arrears. Okay. Tenant can move out. The municipality only does readings the month after for the preceding month, and so those charges can be levied against the tenant. So the assertion that I'm no longer in occupation and therefore I'm not liable for charges is not correct. Okay. Now, with respect to that leads us on to, can they be liable for the sewage charges in this circumstance? Yes, absolutely. Is it provided for within the lease agreement that they would be liable for sewage charges? If so, they can be liable. Whether they've moved out or not is neither here nor there. Okay. I understand the position on there's a mistake and now it's being charged at a later stage. That is a horrible situation to sit in, but these things do occur. And the assertion that we're no longer in there is not really going to take them any further. So yes, they can be charged these. There is one exception, and that is if the tenant had moved out over 3 years ago. It doesn't seem like that is the case, but if that had occurred, there might be some argument in the form of prescription. So they say it's prescribed, you can't actually claim this debt from me. But certainly it doesn't look like that is the case in this particular question. The question is there any legislation which can help us in this particular regard? No, not really. No legislation, I don't think, is going to particularly deal with this issue. But your lease agreement hopefully has a sufficient clause that says you are liable for sewage charges while you're in occupation of the premises. This is such a charge. And, we obviously don't have the benefit of the lease agreement on this particular question. But if you have a substantial lease agreement, your TPN lease, things like that, you can look for certain clauses that deal with acceptance of payments by the tenant. So there are clauses in lease agreements which say any acceptance of a payment by the landlord is not prejudice to any of their rights. And this is something that deals with a circumstance like this. So even though payments have been received previously, that doesn't mean I have consented to write off the charge that I've only found out about at this stage. That is another clause that you can potentially use within your lease agreement. So unfortunately, no legislation to help you out, but your lease should, hopefully, if you've got a good lease agreement in place, it should deal with all manners of this. And yes, absolutely, you can enforce it and claim those amounts from your tenant.
Right. So yeah, thank you very much, Nick. And then the